Good evening. I'm Mark Agrast, Executive Director of the American Society of International Law, and it's my pleasure to welcome you to Tillar House, our historic home here on Sheridan Circle in Washington, D.C., for this evening's conversation with our special guest, Peter Lewis, the Registrar of the International Criminal Court. I also welcome those who are joining us remotely from around the world. Before we begin, I'd like to express our condolences to our members in the United Kingdom for the loss of Queen Elizabeth II. We are honored to have Mr. Lewis with us this evening to mark the 20th anniversary of the Rome Statute. We look forward to hearing his perspective on the work of the International Criminal Court and the challenges it will confront in the coming months and years. I also am pleased to welcome our moderator, Professor Diane Orentlicher, a longtime member and friend of the Society, and David Mandel Anthony, the Senior Advisor in the Office of Global Criminal Justice, whom I will introduce in just a moment. The American Society of International Law is a nonprofit, nonpartisan education membership association founded in 1906 and chartered by the United States Congress in 1950. Its mission is to foster the study of international law and to promote international relations on the basis of law and justice. The Society has long been recognized for its work in the areas of international criminal justice, human rights, and humanitarian law, and it's issued a series of reports with recommendations on the implementation of the Rome Statute and the International Criminal Court. These include the report issued last year by our independent, nonpartisan task force on policy options for U.S. engagement with the International Criminal Court. The report is available on our website at asil.org. The ongoing war in Ukraine has focused renewed attention on the need to ensure that those responsible for war crimes and crimes against humanity are held to account. Although some have urged that a special tribunal be established for this purpose, many look to the ICC to play a leading role in investigating and prosecuting these crimes as it does around the world. I'm honored to welcome David Mandel Anthony, a senior advisor in the Office of Global Criminal Justice at the U.S. Department of State. In that capacity, he's advised the Ambassador at Large for War Crimes issues since 2012, and he has served as the acting director of the Office of Global Criminal Justice from 2021 to 2022. He will offer brief remarks this evening and will introduce Professor Orentlicher to begin the discussion. Mr. Mandel Anthony.
Thank you all for coming tonight. It's my pleasure on behalf of the State Department to introduce Professor Orentlicher and also to welcome Registrar Lewis to Washington for his first official visit as part of the administration's commitment to justice and accountability around the world and to a productive and constructive relationship with the International Criminal Court. My office, for those of you who don't know, advises the Secretary of State and other senior officials at the department on issues related to war crimes, crimes against humanity, and genocide, and in particular on foreign policy for the United States around preventing and responding mass atrocities. And it is in that vein that we have long considered the International Criminal Court to be a critical component of the global architecture for justice, and that we are proud to support. Professor Orentlicher is a professor of international law at American University Washington College of Law. She has lectured and published widely on issues of transitional justice, international criminal law, and testified before the U.S. Senate and House on a range of issues related to human rights. She has served in various public positions, including as Deputy Ambassador in the Office of Global Criminal Justice, and in public international positions at the United Nations as an independent expert on combating impunity and a special advisor to the High Commissioner on national minorities at the Organization for Security and Cooperation in Europe. She's a prolific and noted scholar. On a personal note, I have to say that her scholarship regarding international criminal tribunals has especially focused in some ways on the core of the mandate of those tribunals in reaching affected communities and those victims who need to be engaged in order for the mandates to be most meaningful. And Registrar Lewis, in our conversations today at the State Department, also carries those concerns at the core of his mandate. These are institutions that require a lot of machinery and bureaucracy to work, but at the heart of them is a concern for victims and a desire to make justice meaningful. And with that, it's my deep pleasure to turn it over to our panelists. Thank you.
Thank you, David. It's a real honor to introduce Peter Lewis, who has provided exemplary leadership as Registrar of the International Criminal Court since he assumed his position in April 2018. And it's no small achievement to say for him to have provided that level of leadership when you consider the scope of his responsibilities. He is the Chief Administrative Officer of an exceptionally complex institution, which has been described as, quote, a unique international criminal justice ecosystem, and it's also an international organization. And as David indicated, and as we all know, it's an institution from which so much is expected from so many stakeholders. As administrative head of the ICC, Mr. Lewis is responsible for a host of functions that underpin the delivery of justice, ranging from budgetary and staff and security responsibilities to managing external affairs, ensuring witness protection, and supporting defense counsel. But beyond these vital tasks, the registry plays a key role in realizing the distinctive vision of justice that is reflected in the Rome Statute of the International Criminal Court. And that statute, as many of you know, captures a major shift in the field of international justice, where the post-war tribunals, Nuremberg and Tokyo, and the ad hoc tribunals of the 1990s embodied an essentially retributive version of justice. The Rome Statute sought to expand our conception of justice in a very meaningful way to embrace a fuller range of victims' needs, providing, for example, for the possibility of court-ordered reparations and establishing a novel regime for victim participation in court proceedings. Notably, the registry plays a key role, central role in implementing and facilitating those innovative mandates. Fortunately for the court, Mr. Lewis brought to these wide-ranging and ambitious tasks extraordinary qualifications. A lifelong civil servant and career prosecutor, he served as head of the Crown Prosecution Services in the United Kingdom at the time of his selection to be registrar. And I have to say, I choke at the just saying the word crown today, but he was developed powerful leadership, or applied his powerful leadership skills on behalf of this also complex judicial institution. He also is no stranger to the work of the ICC. Soon after the Rome Statute was adopted, he helped draft the rules of evidence and procedure of the court, as well as the rules on victim participation and reparations. So in light of his experience, it was small wonder that the report of the independent expert review of 2 years ago, which provided a frank assessment of the court's performance on many fronts, hailed Mr. Lewis's election as the registrar as a notable, unqualified success. So it's a pleasure to welcome you. Thank you so much for being here. I'd like to start by asking you some very broad questions, and then maybe follow up with some more specific questions. Since we are, as Mark noted, marking the 20th anniversary of the court coming into existence, it's an appropriate time to reflect on what it has learned, what it's accomplished, and where it has to go. Inevitably, its early years involved a very steep learning curve, particularly given its wide-ranging mandates. So in your own assessment, what do you think are the key lessons we've learned from the first 20 years, both in terms of the court's challenges challenges and its successes? And how can those lessons learned help the court meet the challenges of the future?
If that's the first question, I don't know what happens with the rest. I think responding to the question because of course we're all 20 years, you reflect on how, what have we done, what we've achieved. And we set out to build an institution. And one of the first judges, the German judge at the court, said that the ICC was a construction site for international criminal justice. And that was so true, because you might think that it would be easy to sort of set up the court because you had such experience from the previous tribunals, particularly the ad hoc tribunals. But the truth was that something unique had happened in the court. It was a different idea, and in particular, the role of witnesses and victims in this was going to be treated in a different way. So one of the questions, that I asked myself in, thinking about in this construction site, how had we done, is on those key issues that made us unique. Victims would be able to participate in a meaningful way at each stage of the proceedings. Right? So that was something new. How had we done on that? Of course, witnesses and victims would have the right to reparations, central part of that. How had we done on that promise? How had we found a way to make that work? Perhaps more fundamentally, and the ad hoc tribunals had undoubtedly done this too, it was expected of us that we would communicate with the communities we serve, that it wouldn't be a case of we took this case from a place far, far away and after many years told people what we'd done with it. Fundamentally, we didn't believe we could operate with a system that's designed to have victim participation at all stages of the proceedings unless we found a way of informing them of what we did. So in that, this is just one subset of issues, but as it's what was unique about the court, I think one of the ways we ought to be judged is how we've responded to those. And some of this is straightforward and some of it's not. So victim participation. I was fortunate to be involved at the Paris conference. It was an intersessional conference where we started to think about how you would do that, how you do it for atrocity crimes where you've got potentially hundreds, thousands, tens of thousands of victims. Simply put, how would you allow those people, that many people, to participate meaningfully in the case? That became one of the big issues for the court. And frankly, we came up with a set of rules that allowed that to happen. Would they work? Would they work fairly? There were lots of people who were involved at Paris and subsequently who thought this was a noble experiment that would fail. Not fail for lack of, because we changed our mind about the principle, failed because you just couldn't make it happen. So how did we do on that? The victim reparations, again, it's something that you say, of course we should try and do reparations. How do you make reparations work in atrocity crimes? We've got so many victims and victims living in the most desperate situation. So it's not as easy as finding Peter Lewis, who's a victim of, God forbid, something awful in London, where he's got an address, you can find it. What happens when you're trying to find victims in the most who have been cast to the four corners of the wind, no longer have a home, no longer have any papers identified? How are we judged about making that work? And how are we judged about informing victims about what we do? And I mean, also I'm talking about those happen to be 3 areas of which I've got quite a lot of responsibility to make happen. So I think on the subject of victim participation, we have found a pragmatic means of making that work. So which is basically that, and the rules of procedure and evidence are pretty simple in the end of what we did, which is you can pick your own lawyers, but we couldn't have, if we've got 20,000 victims, we can't have 20,000 lawyers. We can't have 20 lawyers, truthfully. What we've got to do is find a way of finding a common legal representative, which would have to be a compromise. What we try and do is find a common legal representative. And the way the rules work is, if the victims and their lawyers can't work that out for themselves, we can intervene and say, we'll pick one for you. One of these we'll pick for you. Now, that process is working now. So in every case, we have got victims' representatives. They're in the courtroom. If you ever watch the live streaming, you'll see they're there. Is it perfect? No. So, have we found a pragmatic way of making it work? Yes. Is it perfect? No. And at least people tell me it's not perfect. The lack of perfection, if you like, is in many, many places, and you can understand the frustration of this, you have got lawyers, usually working pro bono. I've worked for years with a particular set of victims. I mean, literally years. For Darfur, years and years and years. What happens, and they've formed relationship with the victims, and understandably they say, I've given 20 years of my life for this. I know all these victims. Why not me? Why can't you find a way that I could be more involved? So there are criticisms about how that process works, but pragmatically we haven't found anything better. So I would say the scorecard is pragmatically, we found a way so that there are victims. Perfect? Not yet. More work to be done, but we're struggling to find what would make that shift. In terms of that the cases can proceed, that because one of the criticisms was this idealism that they would be involved at every stage. You've either got 2 prosecutors, that was a lot of people say, this means you're going to have 2 prosecutors in court. The prosecutor and the victim's lawyer is going to be a prosecutor, and the proceedings would grind to a halt. That the judges have found a way to make victims can have a voice at all stages, but they do it at particular times. They have to be as focused as every other party needs to do. So I think not bad for making that work. On the subject of communicating with communities, the problem we've got is the communities are in places usually a long way from the capital, often a long way from the capital, in really rural areas. You've got people who are very poor. Not everybody's got a television. In fact, there may be one television in the village. Radio is used quite a bit, but these are really remote places. They can't tune in to our live stream of the proceedings. So it's so difficult for them to do. So we've had to find innovative ways of getting people involved. There's, I think, northern Uganda, so this is the Lord's Resistance Army. I think the work we've done of going to communities at key moments in the case, so opening statements of the case, closing statements, decisions of the court, we go to the communities, we set up tents, we bring in the screens, so we're actively showing the case. We take representatives of those communities to the court. bring them to the court, tell them, explain about the court. I think we've done a lot of work there, and there's some really innovative stuff that's taking place now as well that we're trying in the Central African Republic. That looks good to me. If we can just replicate that each time, but I think we've learned quite a lot about how to do that, particularly lately, I would say, because we had to learn all this. Reparations, as it turns out, is far more difficult than anybody thought. We can do different sorts of reparations. We can do individual reparations. You've lost something, can we give you some, compensate you? We can do symbolic reparations. You want something to mark that something terrible has happened. Symbolism is hugely important to the communities who want a recognition that something awful happened here. So that can take place. This is the trust fund does this work, and we can do some collective work as well. So making progress, I think.
So sort of following up on that, as we were discussing earlier, one of the maybe most often made observations about the court is that there is a chronic mismatch between its mandate and its vision and the resources that states parties have been willing to commit to the court. So you have this learning curve. You've learned how to do really complex operations, and you've learned what it takes to be effective in many ways, but you don't have the resources to consistently deliver those kinds of programs. And as just kind of a benchmark of the mismatch, a dramatic reminder came in late February when the prosecutor Karim Khan announced his intention to open an investigation into the situation in Ukraine. And he made an exceptional call for contributions beyond the budget, right, the regular budget, of the Office of the Prosecutor, not just for Ukraine, but for all of the situations that his office was investigating. And he said, quote, "The importance and urgency of our mission is too serious to be held hostage to lack of means." And he addressed his appeal for support not just to states parties, but to the entire international community. And I think it's well known that there was an infusion of, striking infusion of support for the ICC. But that's not a consistent level of support. And I wonder if you could elaborate a little bit on what you see the court being able to do that would be desperately important for it to be able to do if it had a greater infusion of funds. And again, not just from states parties, but from non-states parties. And maybe this would be, while you were talking earlier, I was hoping you would say a little bit more about the nature of some of the assistance programs, because I think people who are closely involved with the ICC have a sense of it, but I don't think many people understand what it looks like on the ground to be the beneficiary of the trust fund for victims. Can you say a little bit about that and what?
No, it's a pleasure. And I ought to say at the beginning, the trust fund for victims is within the Rome Statute system, is an independent part. And this is important.
I should have said that.
It's important for fundraising as well. That the trust fund, and I'm an advisor to their board, as well as we cooperate with them to make these things happen. So it's really important. The trust fund has got two mandates essentially. One is the apparently more straightforward one. When the court orders reparations, so there's been a conviction, they make an order of reparations for the victims of those charges. The trust fund gets the money, raises the money, and with the court's agreement, comes up with a scheme for reparations and then delivers it. So that's mandate one. But it's also got a second mandate. It can provide assistance. And the assistance it can provide is not limited to the convictions. And it's not limited in time. So Uganda give me the example in northern Uganda. So the Lord's Resistance Army has been in northern Uganda doing the most horrendous things, even by our standards actually, that you can think of. And investigations have started, so that the case will take place at some stage. But there is a crying need, I'm being emotional about it, there is an absolute need. You've got victims there now who have got very little support. And as an example, there are many, many victims who have lost their limbs because they've been hacked off. There's people who have had terrible injuries. They will have to wait years and for a conviction. But with the assistance program, the trust fund can go in now, and it did. So it set up a scheme in northern Uganda for the victims, any victim of that time, and started to do fantastic work there the trouble is, as you learn, with amputation, lots of the victims have had what you call field amputations. So, they need corrective surgery to stabilize what has taken place. Then they need a prosthetic. So the trust fund has been doing that work with its assistance mandate. In the Central African Republic, which is a poor country, which has gone through repeated waves of violence over the years, trials going on now about some of those events, with convictions or acquittals in due course. But the assistance mandate is there now, and for instance, one of the programs it's got on in the Central African Republic, unfortunately, gender violence is weaponized in many places, and it's certainly happened there. So there are women who are desperate in need of reconstructive surgery. So the assistance program is working there now to bring in a scheme so that there's some access to that. So I'll give you the other example as well that they might do. So, and they need money. I mean, this is sort of a plea from the... In Mali, there's been one conviction. There's a second trial going on now. The conviction... What there's been a conviction on so far in Mali is the desecration of the mausoleums in Timbuktu. Timbuktu, if I should say. So there was a whole series of desperate events of targeting communities. But at that stage, the case the prosecution could bring was for the destruction of these mausoleums, which had a terrible impact, actually, on people and their livelihoods. There is now reparations, court-ordered reparations for that, but it only applies to the case convicted. And there's lots of other communities equally affected by what has happened, but who are not, there hasn't been a case yet. Yes, so the assistance program is going to do a program for those people. So, but the trouble is, and I say this, it's fantastic work they're doing. On an average year, they raise $3 million a year.
And despite the limited resources you've reached, I read the statistics, I should have written them down, but thousands and thousands and thousands. I mean, I think people would be surprised at the number of victims that have been the beneficiary of these. And it's really striking to hear you describe this because, as you know, one of the constant criticisms of victims of the earlier tribunals was as much as they wanted criminal prosecutions, it wasn't enough, and they desperately needed attention to their urgent needs. So the ICC model was revolutionary, but it also responded to a really strong call for victims to provide a more meaningful system of justice. So it's fascinating to hear about that. There's so many things I would love to ask you, but I want to just ask a couple more questions so that we can open the floor to questions from the audience. So we are in Washington, and the Washington relationship with the ICC has been not linear. It's been something of a roller coaster, especially in recent years. And I say that although it's been in flux throughout the history of the court. But I say especially in recent years because it was barely over 2 years ago that a previous administration imposed sanctions on ICC personnel. And now the current administration is very supportive in general of the ICC and its mandate, and has been very forward-leaning in support for its work in Ukraine, which I'm sure is welcome. As we were talking about earlier, one of the things that's striking to those of us who live in Washington is the degree to which there's been really strong bipartisan support in Congress for the ICC's engagement, coming after a period when there were members of Congress who were very concerned about the ICC. So I'm sure that's welcome, but I wonder what your thoughts are about how we might put the U.S. ICC relationship on a more sustainable footing. Obviously, that would be beneficial, but I shouldn't say obviously, I assume it would be beneficial. But I wonder if you have thoughts after being here about a path toward greater stability.
I mean, can I just make the case for, just how important the support of the United States is. It is what difference that makes in the world. Obviously, you're a huge, powerful, important, influential country, but the depth of expertise that you possess. One of the great things about in the State Department today, it was just absolutely spellbinding, actually, and of just the expertise that you could pull in a room of people with such deep knowledge of the country, deep insight into the countries we're dealing with, the influence you can bring to bear on situations and countries, and the influence you can bring to bear on your allies to help and support us. There are 2 people that they're still in the detention center, which I'm also responsible for now, that wouldn't be there if it wasn't for the US. The US got them there. And without your help, there's only so much we can do. With your help, we can be a very, very different organization. And I think what's fantastic about what's happening now is, and it certainly felt it very much to me today, there was this real, first of all, there is no question about the absolute commitment, the zeal and the desire to do something about impunity and really tackle it in the United States. That is absolutely loud and clear. And that they're willing now to recognize that we're part of that architecture. We may not be all of it, we certainly aren't, but we're definitely part of it. And with your support, we can do so much more. And that's one of the things we've been talking about today, is how we could work together within the limits of what's possible and what we can do. So it's fantastic to have you back.
Good.
That's the truth. That's what it felt like. It felt, Uncle Sam's come back, and yeah.
Well, I realized as I was hearing you talk that the work of making it more sustainable really is our work here in Washington more than yours. But we will do everything we can to avoid the fluctuations. I want to ask you just one more kind of specific question and try to maybe a couple of rapid fires and then invite other people to join the conversation. So the report I mentioned earlier, the independent expert review, addressed a really wide range of issues, including things internal to the court, external relations. On the internal side, the court identified some concerns about the court's own workplace environment, particularly as it affects female employees. And I know you've been personally invested in trying to address those concerns. I wonder if you could share with us some of the things you've been personally involved in to try to promote more gender balance at senior management levels and improve the workplace environment for all of your workers?
Yeah, I'm very pleased to be able to talk about that, and I'm very pleased that Antonia's with me to talk about it, because, I mean, just on, you know, there's a huge amount of anecdotes about, as there are in lots of organisations, about examples of what the workplace culture has been, and some pretty unpleasant stuff, really, that just needs discipline and action. And we just revamped our whole discipline system because it wasn't strong enough to deal with these things. We didn't have, you know, so there's some structural things as well. We didn't have an ombudsperson. I don't know if that's much used here, but we didn't have an alternative dispute mechanism, because lots of people want the problem stopped but don't want to make a complaint. So that kind of masks a lot. So we're just presently recruiting an ombudsperson. But to go beyond that to data, when we did our staff survey, we didn't used to do staff surveys. You know, we were really, pre-2018, we were really so old-fashioned. You know, we were like 1950s, not anything else. But when we did our first staff survey in 2018, and you looked at the experience of men and women about their engagement with the court, you know, so how much do you feel, but it's a simple thing, would you say to somebody, come and work in the court, it's a great place to work? It's a simple issue about engagement. You've got no trouble engaging with the mission. Everybody works in the court, and I mean everybody. Everybody you meet in that building is absolutely into the mission. But would you come and work here? So that was the question. There was a 10 percentage point difference between men and women. On that simple question, 10 percentage points difference. So that's the problem we've got to tackle. There's some egregious stuff. We've just got to discipline. We've got to get rid of people. We need alternative dispute. But there's some other things we need to do. So we were very, very fortunate that Antonia happened to be working, and thank God, in the registry as well. And one of the things we realised we needed to do, we're going to do two things. We were going to appoint a full-time gender focal point. We were the first tribunal to do it, appointed, and the gender focal point is Antonia for the moment, would come up with a strategy, gender strategy, to actually address the issues around workplace culture. The three principles of the court has three heads of the three organs of the three principles of the court, the president, the prosecutor, and the registrar. We've all made personal commitments that we are going to make. There will be a strategy, we're going to execute it. Antonia's done a fantastic job with a lot of help from civil society about coming up with a gender strategy. We had extensive consultation. We hope it's going to be formally adopted by the Assembly of States Party at December, but then we have to deliver it. You know, and what we can't have is anything that people feel is tokenism, or we're trying to tick any box. This has got to be real substantive change, but we're determined to do it, and we're determined to put the building blocks in place. And we're going to, we've done a second staff survey, and we've actually specifically measured harassment. So we're going beyond the anecdote now to the actual, give me the numbers on what's happening, what the experience of people is. So we've got hard data that we can be held accountable for and judged on, internally and externally.
Good. Well, I'm sure lots of people will be watching that and hoping for robust implementation, as you say. Okay, just a few short rapid-fire things. I'm going to give you a short sentence, but I'm going to ask you to fill in the blank briefly. Okay, first sentence. During my time as registrar, the issue that has kept me awake at night most often is blank. Fill in the blank.
Witness protection.
I'm not surprised to hear that. Next, I am most proud of progress in blank during my time as registrar.
I think the outreach to victims. I mean, not because I've done it, because the fantastic team I've got have done it. I mean, there's really innovative stuff.
Great, good. This might be my final one, because I need to let you guys ask questions. Okay, while many challenges to the court's performance require change from within, the biggest challenge posed by external political developments in the world, posed to the court by external developments in the world is blank. Biggest challenge.
We've got new threat actors. We've got the cases that are now being investigated, particularly one of them in Ukraine. You've got a new threat actor with real capability. That's a whole new world.
Yeah. I'm sorry, one last question. I promise it's really, really the last one. If I could give my successor only one piece of advice, I would urge her to blank.
Yeah, you've got to have the trust of the state's parties. That is the most important. That's what you trade on, is trust. Without trust, you'll do nothing.
Great.
Earn their trust.
Yes. Good. Thank you so much. Okay, I've been greedy in asking you questions. Are there questions that people would like to ask? I think there's I thought I saw some hand motion, but as a professor. Comments? Okay, I'm going to look at my list then, and I know as a professor that sometimes people in the audience are shy to ask the questions that they have been dying to ask. I'm going to give you guys a minute to do this. Okay, well let me then just, Mark, how are we on time? We have a few more minutes? Okay, we do have a question. I was about to go back to my list of questions. We have one over here. Thanks.
You mentioned that there are other innovative ways that the assistance program is starting to work, and I'm actually quite curious what maybe some of those might be in addition to doing the filmings, screenings, etc. If you can elaborate on this.
Yeah. It's a pleasure to, because we're hoping to get some UN money to help us do some of these things. So it's taking it to a different level. One is in the Central African Republic, this idea of having ambassadors, justice ambassadors. Because one of the things I think the team there realized was you couldn't just, because we're prosecuting a case that took place a number of years ago, about 8 years ago, I think, a series of cases. But there are problems today. And if you're always talking about, can we tell you about something that happened 8 years ago? What does that mean for today? What does that mean about today's problems that need to be challenged? So what you needed was not people who could just tell out, and can I tell you about that story 8 years ago? You need to have people who are champions for justice, who can talk about the biggest, what this is about is part of establishing a framework in which justice is established in the country. And they talk about that. The other issue is, so we do the big screenings at key events, but not everybody can be there. So what they've also doing is they're doing videos, short videos of the case, and they're giving it to bars. Right? Because you do a big thing, you say the ICC are doing something, you set up, they're giving it to bars, and it's fantastic. And this is where I thought, my goodness, I think they've got something. So it's in Bangui, in the Central African Republic. It's a bar, and a bar in the Central African Republic is something to see, it hasn't got a roof. There's a blackboard, and it says, it's in French, Wednesday, and you're not a soccer nation. It says Wednesday, PSG, that's Paris Saint-Germain, football, v Nantes. So it's a football match. Wednesday, 7 o'clock, PSG, v Nantes. Thursday, and it gives the nickname of one of the accused in the case. ICC against Rambo. Right? It's the event. right? So this Paris is a soccer match, and then there's a second event, and you think that is clever, isn't it? But the interesting thing is they've worked out people want to know. People are interested, and I mean, and the guy who's running the bar, he wants to sell beer, right? So he's not going to put in something that's not going to get people through the door. So people want to go through the door. And it goes back to the fundamental issue. The people of the country, it's their lives you talk about. You know, we talk about offences. They're talking about their lives. And I just want to tell you one story, because it's from the Central African Republic. It's the first mission I did as registrar. And everybody said to me, you can't go to Uganda, because that's kind of a nice, introduction. You need to go to one of the tougher places. And, people here have been there. And so I go there, and we have the most fantastic series of events when I'm there, including there's a program for the university, right? So I'm seeing university students. The university, I went to the campus. I couldn't tell it was a campus. I mean, this is desperately poor country, desperately poor country. Anyway, I've got the students there. These are people who are particularly interested in international law. They've studied. But I asked them the question, right? Because the question always is peace without, you can't have peace without justice, right? So I said to them, I'll be honest with you, up until that moment, I'd always thought myself, it's easy to say, but if it was me, if I was a 19-year-old setting out in my life, and I'm going, I was a law student, I'm going to law, would I really want to throw all this up for a trial that's going to destabilise the country? Wouldn't I just want peace so I could finish my studies, get a career, get a family, get married? So I asked them. I asked these students that question. And what they said to me was, our country has been subject to this forever. I heard a little girl singing. And what she was singing, the same thing. I heard a little girl, I want peace, a peace I've never known. And they said to me, we will, as long as people can go through this country and just wreck the place and destroy it with no impunity, it will never stop. But this is the one. And if we're the generation who has to pay the cost of that stopping by dealing with these cases, we'll pay it.
Oh my goodness.
And I'm with this, happened to be with me, the security guy there, French guy, a real tough soldier. Mm-hmm. And he looked at me, and I could feel the hairs on my, hand, and he wanted to have a cry. I nearly had a cry today for other reasons, but I nearly had a damn good cry as well. Mm-hmm. So it was one of those times you think, is this worth it to people? Does it mean something to them? You're talking about their lives, right. Not some case.
Right. No, that's phenomenal. That's a brilliant note to leave on. This has been fascinating. I've learned a lot. I really appreciate not only the daily leadership you provide in a phenomenally challenging job, but the humanity that you bring to this job, which is so necessary in this line of work. Thank you.
Thank you.
Thank you, Wes. Well, this has been a wonderful conversation. I know it will continue. And speaking on behalf of the American Society of International Law, we are also grateful for all of the humanity and attention that you have brought to these issues. On the part of the Society, I hope that you will call upon us to assist in any way that we can as this work continues. And now I just have a brief presentation to make. First, to to you, a memento of your time with us.
Very much. Thank you.
Our speakers is a list, I guess a drinkable list of all of the people who have served as president of the American Society, beginning with Elihu Root, our first president in 1906, and continuing through our 50th president, our current one, Gregory Schaefer. So for each of our speakers, I hope this...
Thank you very much.
I hope you will drink something that you enjoy.